An invisible line exists in the hallowed halls of American justice, a line of judicial temperament and professional respect that must never be crossed. In a stunning turn of events, a Supreme Court justice didn't just cross that line, she obliterated it, aiming a xenophobic insult at one of the nation's former top security officials. What happened next wasn't just a legal rebuttal. It was a defining moment for American identity. If you believe that patriotism is defined by one's commitment to the Constitution and not by the color of their skin or the origin of their name, then you're in the right place. Hit that like button, subscribe to our channel, and comment below with your thoughts. Because the story of how Kash Patel responded to Justice Amy Coney Barrett's shocking comment is a masterclass in dignity and law that every American needs to hear. The grand ballroom of the Washington Legal Conference Center was a universe of quiet power. The air, thick with the scent of old leather and fresh coffee, hummed with the controlled energy of over 300 of the nation's sharpest legal minds. Federal judges with lifetimes of experience, renowned constitutional scholars from Ivy League institutions, and high-ranking government officials filled the ornate chairs, their collective attention fixed on the formidable figure at the podium, Supreme Court Justice Amy Coney Barrett. With the poise of a jurist who had mastered the highest levels of legal debate, Justice Barrett was delivering the keynote address. Her speech, a defense of a robust and expansive view of executive privilege, was both intellectually dense and politically charged. She spoke with a calm, almost serene confidence, her voice echoing through the silent room as she dismissed concerns about unchecked presidential power as hysterical overreactions from those who failed to grasp the grave national security challenges of the modern era. Her presence was commanding, her authority seemingly absolute. Seated in the middle of this sea of legal titans was Kash Patel. To a casual observer, he was just another attendee in a well-tailored suit. But to those who knew, he was a giant in the world of national security. A man born to Indian immigrants in Garden City, New York, Patel had dedicated his life to the service of the United States. From prosecuting terrorists for the Department of Justice to serving as the Chief of Staff at the Department of Defense, he had operated at the highest echelons of power, privy to secrets and responsibilities few could imagine. He listened to Barrett's speech not with deference, but with the focused intensity of a surgeon diagnosing a critical flaw. He had recently completed a comprehensive law review article, a brilliant, meticulously researched piece that directly challenged the very foundations of Barrett's legal philosophy on executive privilege. When the floor opened for questions, a respected D.C. Circuit judge laid out the ground rules, emphasizing professional courtesy. Several hands went up. The moderator's eyes scanned the room and landed on Patel. "Thank you, Justice Barrett, for your remarks," Patel began, his voice clear and measured as he stood. "I am Kash Patel, former Chief of Staff at the Department of Defense." A flicker of recognition crossed Barrett's face. "Of course, Mr. Patel. I'm familiar with your government service." Patel nodded, then launched his intellectual salvo. "I'm concerned your interpretation of executive privilege, particularly in your recent concurrence in Department of Justice versus Richards, lacks historical foundation and could enable executive overreach beyond what the framers intended." The polite academic atmosphere immediately shifted. The air crackled with tension. This was no simple request for clarification. This was a direct challenge to the constitutional interpretation of a sitting Supreme Court justice. Patel proceeded to cite Madison's notes and precedents set by George Washington himself, evidence that directly contradicted Barrett's historical analysis. Barrett's expression tightened, her scholarly composure slipping into visible irritation. "I appreciate your historical interest, Mr. Patel," she retorted coolly, "but the court's jurisprudence has evolved. Contemporary security challenges require flexibility." Patel stood his ground, his response calm but unyielding. "The principles haven't changed, though, Justice Barrett. The balance of powers remains foundational." It was at this point that Justice Barrett made the error that would reverberate through the legal world. Her composure finally broke. With a look of unmistakable dismissiveness, she leaned into the microphone, her voice dripping with condescension. "Perhaps," she said, slowly, ensuring every person in the room heard her clearly, "Mr. Patel would be more comfortable practicing law in his own country." A collective gasp was swallowed by a sudden, deathly silence. The statement hung in the air, thick and poisonous. In that moment, a routine judicial conference had transformed into a national scandal, and a question about constitutional law had become a raw and ugly referendum on who gets to be called an American. Everyone held their breath, their eyes locked on Kash Patel, waiting to see how he would respond to an insult that had crossed every line of judicial conduct. For a few agonizing seconds, the silence in the grand ballroom was so absolute it felt like a physical weight. It was a vacuum of disbelief, where the clinking of a coffee cup or a single cough would have sounded like a gunshot. The moderator stood frozen, her face a mask of horror, unsure how to salvage a situation that had spiraled into a catastrophic breach of judicial decorum. Every eye in the room, belonging to judges, scholars, and officials, was locked on Kash Patel, the man who had just been told in front of his peers that he did not belong. They waited for the explosion, for the righteous anger, for the condemnation that Justice Barrett so clearly deserved. They got something far more powerful. Kash Patel did not flinch. He did not raise his voice. He did not even betray a hint of anger in his expression. He simply stood there, his posture perfect, his gaze steady, allowing the ugliness of Barrett's words to hang in the air and be judged on their own merits. It was a masterclass in controlled strength, a silent refusal to be diminished. When he finally spoke, his voice was not loud, but it cut through the oppressive silence with the clarity of a ringing bell. "Justice Barrett," he began, his tone disarmingly calm. He paused, letting her name and his direct address to her command the room's total attention. "I was born in Garden City, New York." The simple declarative statement landed with the force of a gavel. He continued, building a verbal fortress of American identity, brick by brick. "I am a graduate of American public schools and American universities. I have spent my career serving this nation." His voice remained even, but it now carried an undeniable current of authority. "I've prosecuted the terrorists who plotted to kill my fellow citizens. I've advised American presidents on the strategies needed to protect American lives. I helped oversee the entire United States military, an institution sworn to defend this country, my country." The room remained absolutely silent, captivated. This was no longer a Q&A. It was a testament. What had been intended as a public humiliation was being transformed in real time into a profound lecture on the true meaning of patriotism. Justice Barrett's face, once a portrait of dismissive arrogance, had visibly paled. The implications of her comment and the sheer magnitude of her misjudgment of the man before her were becoming terrifyingly clear to everyone present. Then, Patel made a move that no one would ever forget. He reached slowly into the inside pocket of his suit jacket. A ripple of anticipation went through the audience. What was he reaching for? In a single, fluid motion, he withdrew a small, worn, leather-bound book. He held it up for all to see. It was a pocket constitution. "The Constitution I'm referencing isn't foreign, Justice," Patel said, his voice resonating with the weight of his service. "It's the document I swore an oath to defend. It's the same Constitution I carried in my pocket during national security briefings in the Oval Office and the Pentagon. It was my North Star when making decisions that affected the lives of American soldiers abroad and American families at home." He held her gaze, the small book, a shield and a sword in his hand. "This is my country, Justice Barrett," he declared, his voice unwavering.
I have spent my career serving it, defending it, and upholding its founding principles. Principles like the critical checks and balances that prevent any single branch of government from amassing unchecked power. With that single, masterful stroke, he had not only refuted the personal insult, but had seamlessly pivoted back to the heart of their debate. He had intertwined his own American identity so profoundly with the constitutional principles he was defending that to question one was to question the other. He wasn't just defending himself, he was defending the very document that gave Justice Barrett her authority. The power dynamic in the room had not just shifted, it had been completely inverted. Kash Patel was no longer the one being questioned. He was the one setting the standard.
Having reclaimed the very definition of patriotism, Kash Patel did not dwell on his personal victory. With the pocket constitution still held firmly in his hand, he seamlessly transitioned from a defense of his identity to a defense of the nation's founding principles. He was no longer just a man who had been wronged. He was a constitutional scholar on a mission, and the grand ballroom was his classroom. Justice Barrett, he continued, his voice resonating with newfound power. You often cite the Federalist Papers in your own opinions, so let us turn to them. He didn't need notes. The words were etched into his memory, a part of his very being. In Federalist 70, Hamilton argues for an energetic executive, and I agree, but he explicitly rejects the notion that this energy should be unchecked by the other branches. And in Federalist 51, Madison provides the foundational logic for our entire system. Patel's voice was steady as he quoted from memory, each word a perfectly placed stone building an irrefutable wall of logic. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. He paused, letting the profound wisdom of Madison's words settle over the silent room. The executive privilege doctrine you have endorsed, Justice, risks disrupting this careful balance. It effectively removes a critical check on the executive, placing it beyond the reach of both Congress and the courts. Visibly uncomfortable, Barrett attempted to regain control of the exchange, to reassert her authority. Mr. Patel, you are oversimplifying a complex constitutional doctrine, she interjected, her voice strained. The court's jurisprudence reflects a careful balancing of competing interests. I agree balance is the key, Justice Barrett, Patel responded, instantly, his rebuttal as swift as it was devastating. But your recent opinions have consistently shifted that balance toward executive power without adequate historical or textual justification. Then he delivered the intellectual kill shot. In your Richards opinion, you wrote that courts should presume the validity of executive privilege claims in national security matters. That single presumption inverts the entire constitutional tradition. Privilege has always been an exception that the executive must justify. You have turned it into a right that the other branches must fight to overcome. In the third row, a renowned constitutional law professor from Yale was overheard whispering to a colleague, his voice filled with admiration. My God, he's absolutely right about that reversal of presumption. It's a fundamental shift, and he's just exposed it in plain English. Patel then broadened his argument from the legal to the philosophical, connecting the arcane doctrine to the lived reality of American governance. When I served in government, I witnessed firsthand how excessive secrecy and privilege claims can undermine the accountability that is essential for self-governance. The framers understood this danger. They created a system where, as Madison put it, ambition would counteract ambition, preventing any one branch from accumulating the power of a king. He took a brief pause before delivering his closing statement, a powerful synthesis of law, history, and patriotism.
Therefore, the true patriotic position isn't to grant the executive unquestioned authority in the name of security. It is to defend the checks and balances that have preserved our constitutional republic for over 2 centuries. That is the system I have sworn to uphold, and that is the constitutional tradition I am asking this court to honor. For a moment, silence. Then a single pair of hands began to clap. It was a senior federal judge from the Ninth Circuit. Another joined in, then another. Within seconds, the entire room erupted in spontaneous, thunderous applause. It was a stunning, unprecedented breach of judicial decorum, a tidal wave of support from the very heart of the legal establishment. Federal judges, top attorneys, and legal scholars were all on their feet, not just for the man, but for the principles he had so brilliantly articulated. Justice Amy Coney Barrett sat motionless, her face ashen. The formidable jurist, known for her sharp mind and unshakable composure, had been intellectually defeated and morally rebuked in full view of her peers. As the applause finally subsided, Kash Patel calmly returned to his seat. The president of the American Constitutional Law Society leaned over, shaking his hand firmly. "That," he said, his voice loud enough for all those nearby to hear, "was a clinic in constitutional analysis and professional dignity."
The thunderous applause that had shattered the ballroom's decorum was only the first tremor of a political and legal earthquake. In the moments that followed, the conference's carefully curated agenda disintegrated. Justice Barrett, her authority fractured, remained on the dais for the rest of the Q&A, but the fire had gone out of her. Her answers to subsequent questions were brief, cautious, and devoid of the intellectual confidence she had projected just an hour earlier. Meanwhile, during the ensuing break, a gravitational shift occurred in the room. A steady stream of attendees, judges, law professors, and Department of Justice officials bypassed the justice and made their way to Kash Patel. They shook his hand, clapped him on the shoulder, and eagerly requested advance copies of his forthcoming law review article, the one whose arguments had just been so spectacularly validated. But the story was already escaping the confines of the conference hall. A veteran Supreme Court reporter who had witnessed the entire exchange had already texted her editor a message that would set the news cycle ablaze. "Just witnessed most significant public challenge to Barrett's constitutional interpretation since her confirmation. Patel masterfully exposed weaknesses in her executive privilege doctrine while responding to an inappropriate comment with remarkable dignity. This will be major news." Before the afternoon session had even begun, her prediction was coming true. Video clips of the confrontation, captured on attendees' phones, ignited a digital wildfire. On social media, the hashtags #ThisIsMyCountry2 and Constitutional Scholar exploded, generating over 15 million views in the first 24 hours. The court of public opinion was in session, and the verdict was swift and overwhelming. Major news outlets initially seized upon the most shocking element of the story. Headlines blared across the internet, "Barrett to former U.S. official, go to your country." The Washington Post quoted multiple ethics experts who called the remark a shocking breach of judicial conduct and completely inconsistent with the dignity of the court. But the narrative quickly deepened. Substantive analysis, led by outlets like the New York Times, turned to the constitutional challenge Patel had exposed, with in-depth articles titled, "The Constitutional Challenge: Has Executive Privilege Expanded Beyond the Framers' Intent?" The legal community, a body not given to rash pronouncements, weighed in with remarkable speed and consensus. Scholars from across the political spectrum felt compelled to speak. Harvard law professor Noah Feldman wrote, "Whatever one's jurisprudential views, Patel's analysis of executive privilege limitations is historically sound and deserves serious engagement." In a move that stunned many conservatives, former federal judge Michael McConnell issued a statement. "While I have generally supported Justice Barrett's jurisprudence, Mr. Patel's historical analysis is compelling and well-founded. This exchange should prompt careful reconsideration of the court's approach."
The message was clear: this was not a partisan victory, but an intellectual one. The fallout reached the marble steps of the Supreme Court itself. Facing a public relations disaster and damage to the court's already fragile legitimacy, Chief Justice John Roberts took the highly unusual step of issuing a statement. Without mentioning Barrett by name, he declared that the court remains committed to treating all members of the legal profession with appropriate respect and dignity, adding that robust constitutional debate strengthens our legal tradition. It was a clear and public rebuke. Forced into a corner, Justice Barrett issued her own statement the following day. At yesterday's conference, my choice of words during an exchange with Mr. Patel was inappropriate. I have reached out to Mr. Patel directly to express my regret for the comment. Legal commentators immediately noted the glaring omission. Her apology addressed the personal insult, but remained silent on the substantive constitutional criticisms Patel had raised. Kash Patel's response, when it came, was a final masterclass in statesmanship. His statement was brief and powerful, demonstrating the same dignity he had shown in the ballroom. I appreciate Justice Barrett's acknowledgement and consider the matter resolved on a personal level, he wrote. I remain focused on the constitutional questions regarding executive privilege, which have significant implications for our system of checks and balances. I look forward to continuing this important legal dialogue. He had won, completely and unequivocally, and he had done so by refusing to be dragged down, keeping his eyes and the nation's fixed on the principles that mattered most.
The confrontation between Kash Patel and Justice Amy Coney Barrett was more than a fleeting viral moment. It was a catalyst that permanently altered the landscape of American constitutional law and discourse. Its aftershocks did not fade. Instead, they reshaped the very institutions that had witnessed the clash, creating a legacy that would be studied for generations. The first and most immediate shift occurred in the halls of academia. Law schools across the country scrambled for permission to use the video of the exchange in their constitutional law courses. Georgetown Law Center announced a special symposium titled Executive Privilege Reconsidered, with Kash Patel as the keynote speaker. The American Bar Association invited him to deliver a landmark address on constitutional interpretation and American identity at their annual convention. The demand for his forthcoming Yale Law Journal article was so unprecedented that the online version, when released, was accessed over 200,000 times in its first week, an unheard-of figure for a piece of dense legal scholarship. Top-tier law schools, from Stanford to Chicago, reached out to gauge his interest in academic positions, recognizing him not just as a public servant, but as one of the most vital scholarly voices of his time. More substantively, the exchange began to influence the Supreme Court itself. Court watchers noted a subtle but undeniable change in the tenor of executive privilege cases. In a Chambers opinion issued just 3 weeks after the conference, Justice Kavanaugh cited several of the same founding-era sources Patel had referenced. But the most stunning evolution was in Justice Barrett herself. 6 months after the conference, when the court heard oral arguments in a major executive privilege case, her questions from the bench were markedly different. Gone was the defense of broad executive authority. In its place was a new skepticism, a greater emphasis on the need for congressional oversight. When the decision was announced, legal scholars were stunned. Justice Barrett's concurring opinion took a noticeably more limited view of executive privilege than any of her previous writings. While she did not cite Patel by name, she referenced the very historical sources and principles he had championed. A prominent analyst for SCOTUS blog wrote, "Justice Barrett's jurisprudential evolution on executive privilege is remarkable. Her current approach, emphasizing greater accountability, represents a significant and laudable shift from her previous opinions." The message was clear. Principled, scholarly critique had pierced with sanctum of the court and changed the mind of a justice. Beyond the legal world, the incident became a powerful cultural symbol. For millions of first- and second-generation Americans who had faced questions about their belonging, Patel's calm, dignified response became a blueprint for defiance. A viral LinkedIn post from a young attorney of Middle Eastern descent captured the sentiment. Watching Kash Patel respond to that comment by calmly citing the Constitution and his service to America showed me how to handle these situations with dignity. His message that the Constitution belongs to us all is one every law student should internalize. The incident gave rise to a powerful counter-narrative of patriotism, one not based on ancestry, but on allegiance to the nation's founding ideals. The legacy was finally cemented in brick and mortar, and in print. 1 year after the conference, the American Constitution Society created the Patel Prize for Constitutional Dialogue, an annual award honoring scholars whose work promotes thoughtful engagement across jurisprudential divides. And in a new constitutional law casebook adopted by law schools nationwide, the chapter on executive privilege began not with a dusty 19th century case, but with a full account of the Barrett-Patel exchange. Its introduction concluded, "This incident reminds us that constitutional interpretation is strengthened, not weakened, when diverse American voices participate in our ongoing dialogue about founding principles. The Constitution's promise extends to all Americans, binding us together in a common tradition that transcends our differences." Outro. In the end, the story of that day in the Grand Ballroom is a lasting testament to a profound truth, that in the American Republic, the greatest power does not always reside on a judicial bench or in an executive office. Sometimes it resides in the heart of a single citizen, armed with knowledge, dignity, and an unshakable faith in the country they have sworn to defend. Kash Patel did not just win an argument, he reaffirmed an ideal. If this story of constitutional expertise, dignity, and true patriotism resonated with you, please help us share it far and wide. Like this video, share it with your friends and family, and comment below with your thoughts on this incredible moment. And most importantly, subscribe to our channel for more in-depth stories about the principles that truly make America great.